Hey everybody, Zach Wolf here with another great Top 5 Tuesday. This week on Top 5 Tuesday, it's the top 5 things lawyers shouldn't do on social media in litigation. All of these things really follow from one basic principle. I call it Wolf's first law of social media. It says if you can't do it in real life, then you shouldn't do it on social media. Let's apply that. Number 5, you shouldn't communicate with an opposing party who is represented by counsel through social media. That's pretty obvious, so don't send that person a friend request. Don't like something they've posted. Don't comment on something they've posted. Like I said, that's pretty obvious. It gets a little fuzzier when it's a question of viewing somebody's publicly available social media. Is that a communication? What if the social media platform sends that person a notification that you have viewed their profile? Let's hold that thought. I'll come back to it. Number 4 is you shouldn't give your client bad advice or no advice about their use of social media during litigation. There are 2 basic things that can go wrong with clients using social media during litigation. One is they might post something that's going to hurt them in the lawsuit. The other is they may delete something that is relevant evidence in the lawsuit, and both of those things are bad. So you need to give your client good advice about what to do with their social media during the lawsuit. Number 3 is, this one applies to lawyers and judges. You shouldn't communicate with a judge about a case through social media. Again, that's pretty obvious. Okay, but what about a lawyer and a judge being friends on social media or having a connection through social media? Does that mean that the judge should be recused in the case? Not necessarily. There was a recent Florida case that said the fact that a lawyer and a judge were friends through social media did not necessarily mean the judge had to be recused. The opinion reasoned that, look, everybody knows that being friends on social media is not necessarily the same thing as being friends in the traditional sense. So the mere fact that lawyers and judges are friends through social media, that's okay. Number 2, let's say that your case goes to trial and you have a jury. You shouldn't use social media to communicate with somebody on the jury or on the jury pool. So that means, just like we saw with an opposing party, you've got to be careful when you observe a social media profile for someone on your jury pool. Now, what if you go, let's say on LinkedIn, and you look at somebody's profile and LinkedIn notifies that person. Let's say they have a premium account and they can see who has viewed their profile. Is that prohibited? There is a difference of opinion on this one. Some bar associations in some states have said that if the person on the jury panel is informed that a lawyer has viewed their material, that's prohibited. The ABA has disagreed with that, and Texas appears to be following the ABA approach, at least so far, and saying that it's okay to just passively view social media content of somebody on a jury panel, even if the social media platform informs the person on the jury of that. The reasoning is that really it's a communication from the social media platform, not from the lawyer. Okay, number 1 is you can't take advantage if you learn that somebody on your jury during trial has engaged in some kind of misconduct on social media. If you discover that, you need to promptly disclose that to the judge and to opposing counsel. You can't just keep quiet and then use the knowledge you've learned from that to your advantage. Several bar association opinions have said that. Okay, I hope these tips are helpful for you. Thanks for watching.